Imagine driving down the road thinking the only concern you might have is a traffic stop over something small, maybe a minor violation, something that should end with a warning or a ticket at worst. But instead, within minutes, the situation spirals out of control and ends with gunfire, a man's life taken, and his family left grieving. And then imagine that when that family seeks justice, when they try to hold the officer accountable for the decision that ended their son's life. The courts close the door in their face, telling them that because of a narrow doctrine, nothing that led up to those shots even matters. That is not a hypothetical story. That is what happened in the case that just reached the Supreme Court of the United States and resulted in a unanimous 9-0 ruling that could change how courts across the country analyze excessive force under the Fourth Amendment. The case revolves around an encounter between a law enforcement officer, Roberto Felix Jr., and a young man named Ashton Barnes. Barnes was suspected of toll violations, a relatively minor issue, but one that led to him being pulled over. During the stop, Officer Felix instructed Barnes to exit his vehicle. Barnes initially appeared to comply, opening the door as though he would step out, but at the last second he made a different choice. Instead of surrendering, he attempted to drive away. In that split second, Officer Felix made a decision that would define the case. As the vehicle began to move, he leapt onto the floorboard, clinging to the car as it rolled forward. From that precarious position, the officer fired 2 shots into the vehicle, striking Barnes. The shots were fatal. Barnes managed to stop the car and put it in park. In the moment, he succumbed to his wounds. A traffic stop that should have been uneventful had turned deadly. The aftermath left Barnes's parents devastated. Believing their son's constitutional rights had been violated, they filed a lawsuit against Officer Felix. They argued that the shooting constituted excessive force in violation of the Fourth Amendment's protections against unreasonable searches and seizures. But their path through the courts was anything but smooth. At the district court level, the judge granted summary judgment in favor of the officer. The court applied something known as the moment of threat rule, a doctrine developed in the Fifth Circuit. Under that rule, the only thing that matters is whether the officer was in danger at the exact moment he pulled the trigger. Any actions or decisions leading up to that moment, whether they were reckless, whether they created the danger in the first place, are deemed irrelevant. For Barnes's family, that meant the court would not even consider the full chain of events that led to the officer jumping onto a moving vehicle and deciding to shoot. Instead, the focus was narrowed to a 2-second window when Felix was hanging from the car and arguably in danger. The Fifth Circuit Court of Appeals upheld that reasoning. They agreed that under the moment of threat doctrine, the officer's actions were lawful because he could have reasonably believed his life was at risk in that instant. The broader circumstances, the questionable decision to jump onto the vehicle, the possibility of alternatives were set aside. For the family, it felt like justice had been buried under a rigid and artificial rule. Yet they pressed on, determined to fight the case further. They sought review from the Supreme Court, asking the justices to reconsider whether such a narrow doctrine truly fit within the protections of the Fourth Amendment. The court agreed to hear the case, setting the stage for a showdown that would not only determine the outcome for the Barnes family, but also establish guidance for how lower courts might handle excessive force claims going forward. This is where the story shifts from a tragedy at a traffic stop to a legal battle with national significance. At its core, the question before the court was simple but monumental. Should the analysis of excessive force be frozen at the exact moment of the perceived threat, or should it consider the totality of the circumstances leading up to the shooting? The answer would dictate whether families like the Barneses would ever have a chance to present their full case, or whether officers would continue to be shielded by a rule that ignores everything except the final split second. When the Supreme Court took up this case, it was clear that the stakes were high. Excessive force cases always carry heavy weight, but this one was not only about a tragic shooting, it was also about the framework courts should use to evaluate such tragedies. For years, the Fifth Circuit's moment of threat doctrine had shielded officers from accountability by collapsing the analysis into a tiny sliver of time. The Supreme Court was asked to decide whether that doctrine was consistent with the Fourth Amendment, or whether something broader, something truer to the constitutional promise of reasonableness was required. The justices came back with a unanimous answer. In a 9-0 decision, they rejected the narrow view and held that claims of excessive force must be judged under the Fourth Amendment by examining the totality of the circumstances. That means the analysis cannot stop at the exact moment an officer pulls the trigger. Instead, it must account for everything that happened before and after, all the facts and conditions that shaped the encounter. This was a decisive break in the Fifth Circuit's restrictive approach. Justice Neil Gorsuch authored the opinion laying out the court's reasoning in clear terms. He emphasized that the Fourth Amendment requires objective reasonableness, evaluated from the standpoint of a reasonable officer on the scene, not through the lens of hindsight, but also not through the artificial tunnel vision of a 2-second snapshot. The court noted that reasonableness has always demanded careful attention to the facts and circumstances of each case. To cut that inquiry down to nothing more than a single moment is to ignore the broader picture and to misapply constitutional protections. In practical terms, the court's opinion meant that Officer Felix's decision to leap onto a moving car, his choice to position himself in danger, and the context of Barnes' attempt to drive away all matter. They cannot be swept aside. Whether his actions were reasonable or not must be measured against the whole sequence of events, not just the split second when he felt threatened. This broader standard ensures that courts do not rubber-stamp deadly force simply because an officer created a dangerous scenario and then reacted to it. Alongside the majority opinion, several justices filed concurring opinions that added texture to the decision. Justices Kavanaugh, Thomas Barrett, and Alito each noted the inherent dangers of traffic stops, emphasizing that officers do face real threats during these encounters. They acknowledged that many officers have lost their lives in situations that escalated unexpectedly, but they also stressed that such risks do not justify giving police carte blanche. Danger does not erase the Constitution. Officers must still act within the bounds of reasonableness, and courts must examine the full context before declaring their actions lawful. One of the key implications of this ruling is that lower courts can no longer rely on the moment of threat doctrine to cut off inquiry. Instead, they must dive deeper, considering how an officer's own conduct may have contributed to the danger. Did the officer escalate the situation unnecessarily? Were there alternatives available? Was the threat truly unavoidable? These are the kinds of questions that the totality of the circumstances analysis demands. And while the court stopped short of explicitly ruling on whether an officer who creates danger can then justify deadly force, it left that door open for lower courts to consider. The ruling also carried symbolic weight. A unanimous decision sends a powerful message that this is not a partisan or ideological issue. All 9 justices agreed that the Constitution requires more than a myopic glance at a moment in time. That level of unity adds legitimacy and strength to the precedent, signaling to lower courts that this is not a matter open to creative interpretation. The law is clear: excessive force must be evaluated broadly, not narrowly. For families like the Barneses, that shift is monumental. It means that when they return to court, they will not be silenced by an arbitrary doctrine that ignored the context of their son's death. They will have the opportunity to present the full story, to argue that the officer's choices leading up to the shooting were reckless, and to ask a jury to decide whether those choices violated the Fourth Amendment. It does not guarantee victory, but it guarantees a fairer fight. And for the public, it means that accountability is not just a slogan. It is embedded in constitutional analysis. Courts must no longer turn away from uncomfortable facts or dismiss broader circumstances. Instead, they must confront the reality that excessive force is not always about one instant, but about patterns of decision-making that culminate in violence. The Supreme Court's rejection of the moment of threat rule is a recognition of that reality, and it resets the standard for how these cases will be litigated across the nation. The implications of this decision stretch far beyond one traffic stop in Texas. What the Supreme Court did was restore a measure of accountability that had been chipped away by doctrines like the moment of threat. For years, families caught in tragedies like wrong house raids, mistaken identity arrests, or traffic stops gone wrong were told that the only thing that mattered was a tiny window of time stripped of all the context. That approach left too many victims without recourse, and it gave officers a shield that was broader than the Constitution ever intended. Now, with the court's unanimous rejection of that framework, the message is clear. Accountability cannot be avoided simply by narrowing the focus until nothing but the final trigger pull is left. The Constitution demands more, and so do the people it protects. That means families like the Barneses will finally have the chance to tell the whole story, not just the last 2 seconds of it. It also means future cases will be litigated on a broader record, where juries and judges are free to consider how an officer's own choices shaped the danger that unfolded. This matters deeply for gun owners as well. Imagine again the wrong house raid, an agent breaking down the door in the middle of the night, and a law-abiding homeowner reacting instinctively to what appears to be a violent intrusion. If courts are forced to look at the totality of circumstances, then the fact that the officers failed to identify themselves or used reckless tactics must be weighed in the analysis. It becomes harder for the government to claim immunity when citizens are forced into impossible split-second choices by the very officials sworn to protect them. For ordinary people, that is not just a legal technicality. It is the difference between having a chance at justice or being told from the start that you have no standing, no remedy, no hope. The Supreme Court's decision does not guarantee victory for plaintiffs, but it guarantees that their voices will not be cut off before the facts are even heard. That alone is a significant shift. The case itself is far from over. The Supreme Court vacated the lower court's ruling and sent it back to the Fifth Circuit. That court must now reconsider whether the officer's actions in the full context can withstand constitutional scrutiny. The family will continue to push forward, and the lower courts will need to grapple with the new framework. It may take months, even years, before this particular lawsuit reaches its final chapter. But the precedent has already been set, and it will echo in courtrooms across the country. For all of us watching, the lesson is clear: vigilance matters, and accountability must never be taken for granted. Courts are finally being reminded that the Constitution belongs to the people, not to the government agents who sometimes overstep. And as this case continues to develop, it will remain a reminder of why awareness is crucial. So, if you care about these rights, stay informed, share this story, and make sure others know what the Supreme Court has just done. And if you found this breakdown helpful, don't forget to like, subscribe, and share so that more people can understand why this ruling matters and what it means for our future.